All rise. Veuillez vous lever.
Please be seated. Will the court officer please call the hearing?
Good morning, Madam President. The special session marking the formal opening of the Judicial Year 2025 is now open. La session spéciale de la Cour pénale internationale marqua l'ouverture officielle de l'année judiciaire 2025 est maintenant ouverte.
Dear fellow judges of the court, Her Excellency, Madam President of the Dutch Supreme Court, Madam President and Vice President of the Assembly of State Parties, Mr. Prosecutor, Madam Deputy Prosecutor, Mr. Deputy Prosecutor, Mr. President of the ICC Bar Association, Madam President of the Kosovo Specialist Chambers, Excellencies, ladies and gentlemen, colleagues and friends of the court who are following us online. I warmly welcome everyone to the opening of the Judicial Year 2025 at the International Criminal Court. This annual ceremony serves a very crucial moment for the court and its stakeholders to take stock of historic achievements of this institution, reflect on its role in the rule of law-based international legal order, and reaffirm the court's firm and unconditional commitment towards the mandate for the coming year. 2024 was a particularly momentous year for the court, marked by an unprecedented increase in demand for the court's work in the form of investigations, pretrial proceedings, trials, and appeals. This is expected to carry over to 2025 with several trial judgments that are expected, which will in turn increase the workload on appeal, important activities that are expected in reparations proceedings and pretrial proceedings, which are now expected to further grow from the already very high level of the past year. This only means that the court is becoming more and more relevant as millions of people across the globe live in misery and despair, victims of atrocities, violence, and persecutions. The court for them is a glimmer of hope, and we will spare no energies to provide justice and truth for them. Judges of the court have continued to exercise their judicial mandate with independence, impartiality, and dedication despite external attacks and threats, including arrest warrants against some of them and threats of sanctions. I gratefully acknowledge the outstanding work of the staff of the court. We are proud of the achievement of the court and in the name of human dignity. We will never give up to attempts to undermine and erode the rule of law in the international community. I firmly call on state parties and all nations of the world to stand with human dignity, fundamental rights and liberties, international law, and the International Criminal Court. I respectfully recall the obligations of state parties to protect the court and cooperate with it meaningfully. This is a court of your peoples, and you owe to them and victims of atrocities across the world to live up with your commitments to put an end to impunity for the perpetrators of the most serious crimes of concern to the international community, and thus to contribute to the prevention of such crimes. I would like to conclude recalling the memory of the millions of innocents who have lost their lives and have suffered unimaginable atrocities and persecutions prior, during, and after world wars. Never again, it was unanimously said then. This is where we come from. The creation of the International Criminal Court, I believe, is the crystallization of the endeavor and wisdom of the humankind. This is why the International Criminal Court exists. This is why all nations and all persons of the world should unite and stand with us in the cause of humanity. Thank you. Now, before we proceed further, we have the chance to enjoy a musical performance. This year, we have an unique opportunity to enjoy the performance by Kodama 25, comprising Naomi Sato, who will be playing sho, a traditional Japanese free reed musical instrument, and singer Yoko Bende. As the first Japanese president of the court, it is a particular pleasure to share a part of my culture with you today. I invite Kodama 25 to take the floor. Thank you. Now I give the floor to the prosecutor of the ICC, Mr. Karim Khan.
Madam President, Vice Presidents, distinguished, respected judges of the International Criminal Court, Madam President, Vice President of the Assembly of State Parties, respected President of the Supreme Court of the Kingdom of the Netherlands, President of the Kosovo Special Court, dear Deputy Prosecutors, Acting Registrar, President of the International Criminal Court Bar Association, distinguished members of the Diplomatic Corps, civil society organizations, friends, colleagues, ladies and gentlemen. When I was mulling over what to say in these remarks, of course, one could look at a classical speech on the independence and impartiality of the rule of law, the importance of the law from so many different perspectives, to the individual, to society, to the international community. One could talk about goals and aspirations, mention achievements and accomplishments. But as the President said, the opening of the Judicial Year is not simply ceremonial. It's an opportunity that forces us to pause and to reflect. And my short message, the thrust of my short message today, with the opportunity that I have been given, is really to focus and express gratitude to the staff of this institution, to the work of civil society organizations, and to the states that support us, and most importantly by far, to the heroic, indefatigable courage of victims and witnesses who continue against the odds to have belief that justice can prevail in this cruel world, that continue to speak with us, to give their stories, to give their accounts, who have faced the most pernicious acts possible, believing that an ideal, judges without guns, without arms, with no coercive methods, an institution that is as strong as the states that back it, can prevail to ameliorate the condition of humanity. And we know climate change takes many forms. Madam President, we've seen global warming affecting the oceans. But we've also seen increasingly in international relations for some years now, as global warming goes up, a cooling and indeed a freezing in some parts of international relations. And this freeze without thaw in many areas is fracturing predictability and stability of international relations. And whilst it is cold, it is winter, storms when people come in physically but also metaphorically, whilst warrants may have been issued against elected officials of the court, whilst sanctions may be threatened or imposed against us, I think it's really important to recognize that all of us as elected officials, prosecutor, deputies, judges, registrar, are temporary custodians within our own mandates of something much, much, much more important than us as individuals. In other perspectives, we are, and rightly should be, ships that pass in the night. The best of this court, in my view, the heart of this institution, are our staff. The drivers that bring witnesses and staff to and from airports, the security officers that we have in the court, that we have on the entrance, that we have outside, that keep us safe, the cleaners, the administrative staff, the interpreters, the translators, the lawyers, investigators, analysts, witness protection officers, the travel staff, the financial experts, the outreach officers, in all organs of the court, that every single day, out of the spotlight, labour against the odds to serve. They represent, and it's important to remember that, they represent the collective memory of this place. They represent the best of our values and are the anchor of the Rome Statute in operation, because they work under the guidance of the elected officials and the mandate of the Rome Statute to give effect to the promise of the Rome Statute. So it's only right to recognize this continuity and hope, and to state very clearly, without drama, that however cold the winter, however long the nights may be, or however short the hours of daylight may get, spring will come. Spring will come. And when the green shoots of spring will be seen, and they will be seen, I hope and pray that the staff remember that seeing through this winter and seeing the spring, and even in the Holland we hope for summer, that achievement will very much be down to their perseverance, to your perseverance, determination. And why is that? It's because they recognize this court is not about us as people, staff or elected officials. They realize this court is about justice and the victims, the millions of victims, Madam President, that you referenced in your opening remarks, that look to this institution not as bricks and mortar or glass, but look at it as a promise to the past and a promise to the future, that there can be accountability and a better tomorrow. And when the storms come, it's also important to recall, to strain our sinews, that attacks are not only against individuals or officials or an institution. An attack on an institution that is dedicated to the rule of law is an attack on victims. And understanding that should allow us collectively to join hands with so many states, with so many civil society, with people of good conscience everywhere, to resist, to protect, and to work, and to serve. And the work that this court as a whole endeavours to do every day with fantastic civil society organisations, small, humble ones in refugee camps all around the world, with large civil society as well, with so many states that try to ensure that promises made are promises kept, that they're not sacrificed on the altar of expediency or transactional relationships. That collective effort focused on achieving the goals of the Rome Statute is driven not from some naivety, but because too many in the world, not just the victims, those that are doing work every single day, have seen the consequences when Rome Statute obligations are ignored and societies fragment and the lives of too many innocents are torn apart, ruined, or snuffed out. So to the staff of the court in The Hague and in field missions around the world, to civil society organizations and to states trying to build, as it says on the wall in the hallway upstairs, build a more just world, the message is simple. We have no option to stay strong, to stay determined, and to seek to shield the victims from what they are enduring as we speak. This alliance of humanity that I've referenced, states, civil society, victims and staff, represents a distinguished community of hope, a united alliance who refuse to go quietly into that good night and who endeavour to hear the voices, the prayers and the demands of victims for justice. The drive of our colleagues, their hope and their commitment will ensure unity, and this will ensure, Madam President, that they prevail, this institution prevails, and that justice prevails. Thank you so much.
Thank you, Mr. Prosecutor. I now invite the President of the ICC by Association, Mr. Philippe Larochelle, to make remarks.
Merci, Madame la Présidente. Madame la Présidente, Mesdames, Messieurs les juges, Monsieur le procureur, Monsieur le greffier, distingués invités, chers collègues, l'Association du barreau de la Cour pénale internationale, qui représente les avocats de la défense et des victimes et leurs équipes œuvrant devant la Cour, est heureuse et honorée de pouvoir participer aujourd'hui à la cérémonie marquant l'ouverture de l'année judiciaire 2025 de la Cour pénale internationale. Today, I don't want to talk about the many important issues that the ICCBA is working to improve or resolve in partnership with the court, states, and all stakeholders. I don't want to talk about the provision of appropriate services and support to victims and their legal representatives at the situation stage, or about the absence of viable interim relief for defendants pending trial, or the continuing deficiency in legal aid fees for counsel and their teams. There will be other times for that. Today, I want to speak about the things that unite us, rather than the things that divide us. At the end of the day, we are here because, like everyone else in this room, we believe that this court can contribute to making the world a better place. In preparing for these remarks, I decided to go read the Rome Statute again. And I just stopped after the first sentence of the preamble. That was enough. And I will read it here again. The state parties to the statute, conscious that all peoples are united by common bounds, their cultures pieced together in a shared heritage, and concerned that this delicate mosaic can be shattered at any time. That was enough to inspire these remarks, Your Honors, Madame la Présidente. This is fundamentally what draws us to this court. A certain idea of international justice. One that gives a powerful voice to the victims of crimes that shock the conscience of humanity. One that puts an end to impunity not by a firing squad, but by a fair trial. One that ultimately will dissuade and prevent the commission of the most atrocious crimes humanity has seen. And that's why we rejoice when the prosecutors, and we rejoice with the rest of the international community, or most of it anyway, when the prosecutor, when warrants of arrest are sought or issued in situations throughout the world where alleged mass crimes are taking place for all to see, whether Ukraine or Palestine, Bangladesh, Myanmar or Darfur, and when these warrants of arrest are sought on the basis of that most fundamental of principles, that all are equal before the law, no matter their position, and all are deserving of the law's protection, no matter their nationality, ethnicity, gender, or station in life. Like the rest of you, we are profoundly shocked by the notion that some states would be so opposed to that ideal of international justice that they would seek to sanction this court and find various and vicious ways to impede its work. What does it tell us? There are forces in this world that still oppose equal accountability, that seem to prefer violence and conflict over justice and peace when the former serves its perceived interest. These attempts to undermine the court only show how necessary and relevant our work remains, while sanctions and threats only reinforce our determination to carry out fair judicial proceedings within the courtrooms of this building and have a positive impact on the lives of the affected communities in whose names we act. These attempts also show not only how delicate the mosaic of international justice is, but also how fragile. And what work remains ahead of us if we want to leave our children with a more peaceful world and a more developed and acute sense of international justice. With and through our members, the ICCBA is reaching out to bar associations, universities, and NGOs in every corner of the world to continue garnering support for the court and its work and to seek allies and build coalitions to ward off these unfair sanctions. Our cause is just. The ICCBA and its members will not allow international justice to be bullied. With the rest of you, we will stand in the way of those who oppose this court. Je souhaite encore aujourd'hui terminer.
Today, I would like to conclude in French, and I will use a quotation attributed to Gandhi, who is supposed to have said that the greatness of a nation can be judged by how it treats its weakest members. And yet, Madam President, the weakest people in our institution are the members of the defense and victims teams. They are underpaid, exposed, vulnerable, and benefit from minimal social protections. The current sanctions expose the court to a deeper assessment of its functioning and the manner in which it works, or rather, it treats the people working there. Whereas the credibility of the institution is more important than ever, it is crucial that the court should provide a conducive environment of work that is fair to everyone working there, whether they are permanent employees or temporary employees working with the accused persons and the defense. But I would like to reassure you that we will not wait for these things to happen before deploying ourselves in defense of the court. We are already used to doing a lot more than what we are being paid for. And these sanctions will merely increase our motivation to continue doing what we are doing. And I would like to conclude by insisting that the court should treat us with dignity. You should listen to us outside of the courtrooms so that the unrelenting work and the contribution of its members should get the recognition that it fully deserves. Thank you for your attention, and I wish you a judicial year crowned with success, suspects, and especially accused persons.
Dubisson, the Director of the Division of Judicial Services. Mr. Dubisson will deliver remarks on behalf of Registrar Osvaldo Zavala Hilar, who unfortunately could not attend today's ceremony. Mr. Dubisson, you have the floor.
Madame la Présidente,
Madam President of the Court, Madam Vice President, Madam President of the Court and Vice Presidents, Your Honour, Mr. Prosecutor, Deputy Prosecutors, Mr. President of the ICC Bar Association, Madam President and Vice President of the Assembly of States Parties, Madam President of the Kosovo Specialist Chambers, His Excellency, President of the Supreme Court of the Netherlands, Your Excellencies and distinguished guests, colleagues from the Court. It is indeed a great honour to address you today on the opening of the 2025 Judicial Year. In this, the 24th year of the International Criminal Court's existence. The inauguration of the new Judicial Year presents a valuable opportunity to reflect on the year behind us and to look forward to the opportunities and challenges ahead. On behalf of the Registrar, I thank those who have remained steadfast in their support for this institution over the last year. I would like to wish you all a very good Judicial Year. Excellencies, ladies and gentlemen, the year 2024 saw a substantial level of activity at the Court. We conducted 163 public court hearings, throughout which the Registry supported 73 witnesses to give evidence, facilitating their testimonies both in person and via video link. The ICC remains ever committed to victim-centered justice and supports 13,012 victims participating in proceedings this year, always guided by the objective to render meaningful, inclusive, and secure victim engagement. 2024 presented an opportunity to build upon our excellent partnership with the TFV, supporting the implementation of reparations in both the Taganda and Ongwen cases, both of increased size and relevance. The successful management of last year's substantial judicial caseload would not have been possible without the hard work, resilience, and resourcefulness of my colleagues in the registry. Last year, we supported 101 missions for the defense and legal representatives of victims. We made more than 323 requests for cooperation to states and the United Nations. We provided protection through the ICC PP to 110 witnesses and their dependents, in total around 700 individuals. The language services section provided more than 2,496 interpreter days, providing services in 28 languages. And the information management services sections remained committed to fulfilling the information technology needs of the court. The registry remains dedicated to enhancing and streamlining the court's operations by continuously improving practices through strategic and policy developments in line with our mandate and core values. This includes the implementation of the new legal aid policy, revising the victims' strategy, and organising the seminar on medical matters in detention. Looking forward to the year ahead, we find ourselves facing an unprecedented and concerning reality, wherein the court is increasingly subjected to attacks seeking to undermine its ability to fulfill its mandate. In the midst of these challenges, we must not lose sight of the court's fundamental purpose: to deliver justice for victims through the Rome Statute system and to provide a permanent mechanism for addressing the gravest crimes. In 2025, the registry will drive progress on the victim's strategy. It will facilitate effective victim participation and engagement, which is crucial to the work of the court. A draft report is currently being prepared addressing the evolving needs and challenges faced by victims within the Rome Statute. We will engage with internal and external stakeholders, as well as with the victims themselves, in order to produce a holistic, victim-centred strategy. In 2025, the registry will not deviate from its goals. We are fully prepared to support the functions of the court in judicial, cooperation and administrative activity, working together under the one court principle, despite the adversity we may face. As such, we have taken measures to secure the court's operations in 2025, including the implementation of the cyber security blueprint, improving our capabilities to monitor and detect malicious activities. In the face of repeated efforts to disrupt our delivery of justice, we must remember that to the victims and communities who are hungry for justice and peace, the work that we undertake here at the ICC matters, and we must continue it. I would like to make the most of this opportunity to, on behalf of the Registrar, thank the staff and personnel of the court, thank our state's parties, the host state, civil society organizations, and other stakeholders for their trust, their support, their commitment that continue to enable us to fulfill the mandate of this organization. And I thank you.
For his remarks. I will now invite Kodama 25 to perform for us for a second time.
「上を向いて歩こう」「涙がこぼれないように思い出す」「春の日ひとりぼっちの夜」「上を向いて歩こう」「滲んだ星を数えて思い出す」「夏の日ひとりぼっちの夜」「幸せは雲の上に」幸せは空の上に上を向いて歩こう涙がこぼれないように泣きながら歩くひとりぼっちの夜ラララララララララララ思い出す秋の日ひとりぼっちの夜悲しみは星の影に悲しみは月の影に上を向いて歩こう涙がこぼれないように泣きながら歩くひとりぼっちの夜ひとりぼっちの夜
I'd like to thank Naomi Sato and Yuko Bende for enriching today's ceremony with these lovely performances today. Thank you. I now have the great pleasure to introduce today's guest of honor and keynote speaker, Her Excellency Tineke de Groot, President of the Supreme Court of the Netherlands. After studying law and humanities at the Vrije Universiteit Amsterdam and the University of Vienna, President de Groot has been a member of the judiciary in the Netherlands since 1990. She was appointed to the Supreme Court of the Netherlands, or Hoge Raad, in 2012 and was successfully nominated to the position of President of the Supreme Court in 2020, thus being the first female president in the Dutch Supreme Court's history. Since 2011, President de Groot is endowed professor at the Vrije Universiteit Amsterdam, appointed to the chair of Judiciary and Conflict Resolution. The Netherlands is a state party which, in line with the principle of complementarity, is tasked with the responsibility to prosecute crimes falling within the jurisdiction of the court at the domestic level. Dutch courts, in this regard, has had a vast experience dealing with these crimes. But importantly, the court and the Netherlands also has a unique relationship, and as a host state, the Netherlands plays a critical role in the day-to-day operations and in ensuring the safety and independence of the court. It is therefore a particular honor to have the president of the highest court in the Netherlands as our keynote speaker for this year's ceremony. President de Groot, you have the floor.
Thank you. Madam President, I apologize for my last name. It is too Dutch. Madam President, dear Vice Presidents, members of the Court, the Prosecution, the Bar, the Registry, Court staff, Excellencies, ladies and gentlemen. It is a pleasure and an honor to address you today on the occasion of the opening of the Judicial Year of the International Criminal Court, which is an institution with strong relations to all of you, to the United Nations, to the international community acting against impunity of the most serious crimes of concern, to the international community as a whole, to national courts, and to the people for whom the values of humanity are defended. As the President of a national court, the Supreme Court of the Netherlands, it so happens that I have come to underline our strong institutional proximity to the ICC, while we also work in close physical proximity to one another. Here in The Hague, the international city of peace and justice. For many years now, the International Court of Justice, the International Criminal Court, and Supreme Court of the Netherlands invite in turns, within the framework of the so-called The Hague Judicial Club, our members and members of other international tribunals in The Hague to meet one another and to reflect on common topics of administering justice by courts with the kind support of the Mayor of The Hague. The mandate of the ICC to try persons who are accused of the most serious crimes of concern to the international community, the crime of genocide, war crimes, crimes against humanity, and the crime of aggression, is a mandate which is based on public international law. Nowadays, people live in a global constellation, with a level of armed conflict and violence the world has not seen since the Second World War. Virtual reality coexists with reality, and truth-seeking is undermined. It is as important as it has ever been that international treaties and national legislation uphold and further the rule of law-based democracies and protect the fundamental rights of the people. Providing for such treaties and legislation is up to politicians, who have a primary role in preventing the repetition of the age-old story in which societies collapse onto themselves in cycles of threats, violence, exploitation and abuse. Social collapse into those cycles brings with it a high risk that the most serious crimes of concern to the international community may occur, and forcing compliance with the law ultimately goes through courts, our courts. Reducing impunity for the most serious crimes of concern to the international community as a whole, and from now on I will just refer to international crimes, is a comprehensive activity. The commitment to do so through international law, by which states, similar entities, and people are bound, is not yet so old. For instance, my court has existed since 1838, and its predecessors date back to the time of Grotius. Nevertheless, in the Netherlands, legal development in this area until 2002 was rather limited, considering the developments from 2002 onwards, when the Rome Statute entered into force and established the ICC. Developing this form of binding international law builds on experiences with regional war crime tribunals and on a long-standing tradition of mutual legal assistance in civil and criminal matters. And the work on effectuating this binding international law is work in progress, and it is far from easy, as we already heard today again. It requires, apart from legal expertise, courage, wisdom, and faithfulness to humanity. But the mere existence of this body of binding international law supports the community of states to implement it and to encourage greater acceptance of its value to people. In doing so, the use of the concept of a proper administration of justice is clearly recognizable. This concept is a familiar element of the tradition of mutual assistance in criminal matters. And now I would like to share observations on changes and developments in the Netherlands in connection with the mandate of the ICC. In the Netherlands, the Rome Statute gave rise to more coherent legislation on jurisdiction and on individual criminal responsibility in cases with an international element, and on the cooperation of national authorities with the ICC. The principle of complementarity in the Rome Statute is an incentive for further developments with regard to investigations, prosecutions, resulting in trials and sentencing. In general, we could see the complementarity principle as part of the concept of a proper administration of justice, evolving into more concrete terms. In the Netherlands, as well as in many other jurisdictions, traditionally a humanitarian concept of a proper administration of justice underpins legislation on the cooperation between states in criminal cases with an international element. It is rather an open concept which promotes the balancing of interests of the individual case. The concept includes aspects like concentrating the prosecution at the most appropriate time and place, complying with the principle of ne bis in idem, finding the most suitable places for prosecution, trial and enforcement from the perspectives of the state where an international crime took place, the detained defendant or convicted person with needs for resocialization, victims and societies who need to be able to observe that justice is being done. The concept also entails aspects and interests like the enforcement of the law, fair trial, truth-finding, social acknowledgement, reconciliation, and restorative justice. In the era before the Rome Statute, it was already common in the Netherlands to pay attention to this concept of a proper administration of justice when dealing with criminal cases with an international element. And this was not only done by the legislature, but also by the police, the prosecution, and the courts. The Rome Statute and subsequently the ICC have encouraged increased attention for this concept. They have also directed attention towards a more systematic legal approach toward international crimes. The Rome Statute and the ICC support the sharing of relevant knowledge and experience, and they further legal certainty with the aim of reducing impunity of international crimes. In creating such legislation, the Dutch legislator acknowledged that according to the principle of complementarity embedded in the Rome Statute, the primary responsibility for preventing impunity for suspects of international crimes lies with the states parties to the Rome Statute. The Dutch legislator also expressed that as the host country of several international tribunals and international courts in The Hague, the Netherlands has a special role and responsibility in preventing impunity for persons guilty of international crimes. In this context, domestic rules for jurisdiction and individual criminal responsibility are aligned with those of the Rome Statute in the so-called International Crimes Act of 2003. In this act, the possibilities for investigation, prosecution and trial of international crimes in the Netherlands have been significantly expanded. For several crimes committed before the International Crimes Act came into force in 2003, the 1952 Act on War Crimes is also worthy of note. This War Crimes Act established individual criminal responsibility for and universal jurisdiction over war crimes, taking into account the obligations under the 1949 Geneva Conventions. There is a special division of Dutch Public Prosecutor's Office, which deals with the prosecution of international crimes. It cooperates, for instance, with the International Crimes Team of the Dutch Police. Cases originate from different sources, like, for example, individuals or organizations, non-governmental organizations, who report a criminal offense, a legal aid request from a tribunal, or immigration authorities who have serious reasons for considering that a person seeking asylum has committed a crime against peace, war crime, or a crime against humanity. Now, I would like to provide some examples of cases that have been brought before Dutch courts to demonstrate further changes and developments of the law in the Netherlands on reducing impunity of international crimes related to the mandate of the ICC. In contrast to the current approach of this Dutch International Crimes Act, which implements the Rome Statute into national law, previous Dutch legislation was treaties-oriented. An early example of this earlier approach can be found in the Dutch case concerning Desi Bouterse, former president of the Republic of Suriname, who passed away last month. In 2000, a Dutch Court of Appeal ordered at the request of interested parties that the Public Prosecutor's Office prosecute Bouterse for his involvement in the torture and subsequent murder of 15 opponents of the military regime led by Bouterse in December 1982 in Suriname. Suriname was a Dutch colony until it gained independence in 1975. The Court of Appeal considered the prosecution of Bouterse in the Netherlands appropriate because this prosecution in Suriname or elsewhere in the world was not to be expected in the near future, and because of the close historic ties with Suriname. A large population from Suriname lived in the Netherlands, and at least one of the victims was a Dutch national. At the time of that order of the Court of Appeal, legislation in the Netherlands provided extraterritorial universal jurisdiction for torture based on the Act to implement the Torture Convention. However, as the Act had only entered into force in 1989, 7 years after what happened in Paramaribo, the legal basis of the prosecution had to be, according to the Court of Appeal, customary international law, combined with a retroactive application of this law. The Procurator General at the Supreme Court of the Netherlands filed a request for cassation in the interest of the law, seeking annulment of the Court of Appeal's decision. The Supreme Court ruled in 2001 that indeed the principle of legality, which is part of the Constitution and the Criminal Code in the Netherlands, prohibited the retroactive application of since established universal jurisdiction over torture, regardless of whether customary international law provided for universal jurisdiction. As the legislator, had not explicitly provided for the retroactive application of the Act to implement the Torture Convention. Later, Bouterse was prosecuted in Suriname. This led to an irrevocable conviction for his involvement in the so-called December killings by the Court of Appeal of Suriname in 2023. 6 years after the Supreme Court judgment of 2001 in the Dutch case concerning Bouterse, the finding in that judgment that no retroactive application to the expansion of the jurisdiction had been provided for by law was followed in another case. After the Dutch Public Prosecutor's Office had initiated the prosecution of Mpambara, who resided in the Netherlands where he requested asylum, was prosecuted for war crimes and torture in Rwanda in 1994 by the Dutch Public Prosecutor's Office, then the prosecutor of the Rwanda Tribunal requested that the suspect also be prosecuted in the Netherlands for the crime of genocide. This genocide part of the prosecution was later ruled inadmissible. In its judgment of 2008, the Supreme Court decided that the fact that the accused resided in the Netherlands was not sufficient for jurisdiction, because the International Crimes Act, allowing to prosecute somebody residing in the Netherlands for genocide committed elsewhere, only came into force in 2003. This time, the Supreme Court added that neither in the International Crimes Act nor elsewhere retroactive effect was accorded to this jurisdiction provision, even though, had the legislature wished to do so, also in view of Article 7, Part 2 of the European Convention of Human Rights, no rule of law would have precluded that retroactive effect. This last remark did not go unnoticed by the legislature. In 2012, a change in the International Crimes Act added universal jurisdiction for genocide committed as of the 24th of October 1970, on which day the Act to implement the Genocide Convention came into force in the Netherlands. This dialogue between the legislature and the court demonstrates the approach of the Dutch International Crimes Act, aiming to not just implement the Rome Statute in national law, but also to reduce impunity of international crimes in connection with the mandate of the ICC. The increased attention for the investigation, prosecution, and trial of crimes which are included in the Rome Statute and the National International Crimes Act is visible in other court judgments, which are published on the website of the Judiciary of the Netherlands in open access. Generally, since 2000, there have been cases in the Netherlands on genocide, crimes against humanity, war crimes, and torture. Cases concern international crimes in several countries, like Afghanistan, Ethiopia, Iraq, Liberia, Rwanda, Sri Lanka, and Syria. And the first irrevocable conviction based on universal jurisdiction dates from 2004. It concerns acts of torture in the Democratic Republic of Congo in 1996. The Dutch court applied the definition of torture in the Convention, UN Convention Against Torture, as enacted in the Dutch Act to implement this torture convention. And recently, a Dutch first instance court convicted a Dutch national for enslavement while resident in Syria. The victim was a Yazidi woman. This was qualified as a crime against humanity. The court applied the International Crimes Act and the definition of crimes against humanity as stipulated in the Rome Statute. Sometimes such cases are brought before the Supreme Court following judgments of first instance and appeal courts. This occurred, for instance, in 2017 in 5 cases against activities of the Tamil Tigers. The individuals were convicted of participating in an organization with the purpose of, in short, committing international crimes in Sri Lanka, committed as part of a widespread and systematic attack directed against the civilian population, the Tamil population. These cases reaffirmed the principle that in a case of internal armed conflict, where international humanitarian law applies, the application of national law, national criminal law, is not excluded. In more recent case law, notably in the realm of terrorist offenses, we can also observe various hybrid prosecutions. These are cases which combine one or more prosecutions based on the International Crimes Act with prosecutions based on Dutch criminal law involving offences not considered international crimes and not included in the Rome Statute. In such a case, the Public Prosecution Service may, for example, combine charges for the crime of participating in an organization with the intent of committing international crimes in violation of Dutch legislation following the Rome Statute, with charges for the crime of participating in an organization with the intent of committing terrorist offenses. An example can be provided by a case in which a person was convicted by the Appeal Court of The Hague and sentenced to 7 years in prison for participating in an organization with the aim of committing terrorist offenses and for violating Common Article 3 of the Geneva Conventions, consisting of assault on personal dignity, in particular degrading and humiliating treatment. In the case of a non-international armed conflict, the accused was a Dutch national who went to Syria in 2014, where he participated in a banned jihadist organization with the aim of committing terrorist crimes. He also posed on a picture next to a man who had been hung on a cross. He posted this picture on his Facebook page, and then the picture was distributed to a large group of young people in a Dutch city. A final appeal in this case to the Supreme Court was dismissed. I would like to conclude with some words on a proper administration of justice as a main element of the cooperation between the ICC and the host state, the Netherlands. International cooperation and judicial assistance are part of the Rome Statute and as such also based in international law. As the legislature of the Netherlands indicated, cooperation of national authorities with the ICC is a significant responsibility in view of the common aim of preventing impunity for persons guilty of international crimes. It is even more significant for the ICC's host state, who facilitates that lawyers, suspects, witnesses, experts, and the public can come together in order to see justice being done. Earlier this morning, we were able to observe the opening of the Judicial Year as an occasion to pause and to reflect on the Court's activities, the Court's commitment towards its mandate for the coming year. In a way, the opening of this Judicial Year may also be seen as an occasion to reflect on the perspectives of solidarity, pragmatism, and effectiveness, which were leading in the creation of the Rome Statute and ICC's mandate. Both the ICC and national courts play a crucial role in reducing impunity for international crimes as part of this proper administration of justice. In essence, the national courts and the ICC share common perspectives of solidarity, pragmatism, and effectiveness. These three perspectives are inherent to the functioning of the Rome Statute, and they encourage us to move forward firmly, though prudently, towards legal certainty, on reducing impunity. Let us keep them in mind in the coming year and stand together for the proper administration of justice. Thank you, Madam President, for the invitation, and thank you all for your attention.
Madam President de Groot, thank you very much for your insightful remarks, which eloquently illustrated the activities of Dutch courts. I do strongly echo your hope that this will be an occasion to reflect on the perspectives of solidarity, pragmatism, and effectiveness that lead to the creation of this institution. Excellencies, ladies and gentlemen, we have arrived at the end of this solemn hearing. In a moment, I will have a chance for more informal discussions in the lobby of the court, with coffees, tea, and light snacks. Once more, thank you all for joining us at this symbolic event and thereby expressing your commitment to our noble mandate. As I have mentioned in my opening remarks, it is now for us all, but importantly, state parties, to take action to live up with this commitment. What we have before us is a litmus test for our collective commitment to international criminal justice. I firmly believe that by taking determined action together, guided by our unwavering commitment to fight impunity against the most serious crimes of concern to the international community and towards victims of these crimes, the court and the rule of law in the international community will be able to come out stronger and resilient than ever. I hereby declare the Judicial Year 2025 of the International Criminal Court opened. This hearing is concluded.
All rise, we vous lever.